As long as we're careful to avoid overdoing it, I think the language of rights gives us a supple and powerful way of expressing important moral propositions, like the right of a human being not to be directly killed or unjustly killed. I see rights as expressing principles of justice, like the one I just articulated. They are principles of justice, and they express requirements of justice from the point of view, or considered from the point of view, of the beneficiary of the requirement, the rights bearer. That's what a right basically is. So I'm not in the strong anti-rights talk crowd, but I don't think we can do all the moral analysis that needs to be done with the language of rights. And I don't think we actually need the language of rights to do any of it, need the language strictly speaking. We can translate propositions of rights talk into other language while capturing the core insights. Still, I think it's useful, and we ought not to get phobic about rights language and refuse ever to speak in terms of rights. There's a reasonable position where we don't throw the language of rights entirely overboard, but we also don't imagine that we can solve all our problems, handle every moral issue, by analyzing the issue in terms of rights, or that there's no other language to express certain important principles of justice apart from the language of rights. I benefited enormously in my own education on this issue from reading the works of the Yale legal scholar Wesley Hofeld. He gave us a very useful way of analyzing rights, whether we're talking about legal rights or moral rights. One of his key insights is that we tend to speak of rights as two-term relations. So consider free speech, the right to free speech. There's me, and there's free speech. I have a right to free speech. Now, Hofeld points out that that's actually analytically not very useful. I mean, it might be good political rhetoric, but it's really not analytically useful. To be analytically useful, we need to think of rights as three-term relationships. Relationships between two persons, or at least two persons, and a subject matter. Rights are three-term relationships. Hofeld's other big insight was that rights are correlative. There are different types of rights. Certain rights are correlative to duties. Certain rights are really liberties and are correlative to the absence of a duty. Rights in a certain sense are not philosophically basic or foundational. If we keep tracing back chains of practical reasoning to the first principles of our practical thinking or practical reasoning, we're not going to end up at rights. Rights are rather conclusions. They're down the line of chains of reasoning that begin with the identification of human goods or values, the constitutive aspects of human well-being and fulfillment, the more than merely instrumental reasons for action that we human beings have. What Aquinas calls the first principles of practical reasoning refer to the basic human goods that give people their most fundamental reasons for acting. From these first principles of practical reason, we can, on reflecting that is on their integral prescriptivity or directiveness, identify duties, moral norms, for example, including duties or norms of justice. And correlative to those duties, at least in some cases, are rights. We look at the duty, that is to say, from the perspective of the beneficiary of the duty, the rights bearer. But rights are not, as I say, philosophically foundational. Human goods or values, the things that give us the most basic reasons for our actions, the non-instrumental or more than merely instrumental reasons for action that we have, are at the foundation of all practical thinking, including all moral thinking, including all thinking about justice.